Good morning, it's Bob Massey, Facebook Live, and today I want to talk to you about something, even though we're in the Christmas spirit. You see, these are things that we should always be looking at, particularly if you do not have a will or trust. Let me talk about a few things. First of all, you do not have to have a lot of money in order to do a living trust, but I'm going to sort of distinguish some things so you have a clear understanding of how a will works and how a trust works. First of all, a will and a trust are what we call testamentary documents. They're things that basically are saying what you want if something happens to you. And one of the biggest problems I have is a lot of young couples who have minor children. They don't have anything whatsoever. They don't have a will. God forbid if there be a common accident, who's going to take care of the children? How the children are going to be raised? How do you want their college to be taken care of? Do you have life insurance? How do you want that money to be used for purposes of raising your children? Things of that nature. Who's going to be the guardians of the children? Who do you trust enough to raise your children? And because you're young and you're growing your estate and you're involved in raising your children, you don't think about these type of things. And I understand that. But all too often, I've seen some unfortunate things happen where nothing is set up. So in the state of Nevada, when you have a will, you have it executed by two witnesses in a lawyer's office like mine. And the witness attests the fact that you're competent to enter into this will that basically explains how you want your estate to go. With a trust is a document that is created for purposes of avoiding the need for what we call a probate process. And a probate is when somebody dies and you have to go through the courts in order to fulfill the wishes of that party. A living trust, what happens is whatever assets you have, except like vehicles, unless they're very expensive vehicles, you put those assets into the name of the trust. So, for example, Mr. and Mrs. John Doe, they own a house, they have a piece of property, they may have a stock account, and right now everything is in joint names. Well, that's great because if something happens to the one, it automatically is going to go to the survivor. That's what we call joint tenancy ownership. But what if there's a common accident? So with a common accident, if you don't have a trust set up, then all of those assets have to go through the probate court in order to have it distributed according to the terms and conditions of the will. And if you do not have a will, then it's going to go by the way of what we call intestate succession. It means you died without a will and you go through the tree of life. When you create a living trust, the house you own, the stock brokerage account you own, the bank account you own, we transfer that into the name of the trust. And now you and your wife or you and your partner are basically the co-trustees of the trust. You created a trust, you manage a trust, it's revocable. You could change it anytime you want. You could sell your assets. The most important thing is always follow the money and always make sure that it's put into the name of the trust. Now, if one passes or if there's a common accident, then it automatically does not go into probate now because the trust lives on. That's why it's called a living trust. The other thing you always want to do, again, if you have minor children, is create the will. You don't necessarily have to have a trust, but depending upon what assets you have, I counsel you, you name that guardian. Now, who is that person going to be? Families sometimes can become very complicated on these issues. You have grandparents that still may be young, or parents and the children have their grandparents and may be young enough that, God forbid, if there's a common accident, you want certain grandparents to raise the children. Do you want them to raise in a certain religion? These are things that you have to think about. If you don't think about it, God forbid, something happens, it's basically left up to the courts. And then you have family members fighting over it. Be clear in what you want. When I meet with you, I go through a legal consultation. It's very affordable. You come in, we discuss it. I give you a form to take with you. You fill out the form, you send it back to me, and I review it and say, okay, this is what we're going to do. And so in addition to that, we do what we call medical durable powers of attorney for who's going to make medical decisions. But the most important message I want you to understand here is depending upon your age and your situation, most people should at least have a will, surely should consider having a trust along with a will. It's called a pour-over will, and these other medical documents. And once it's set up, to be honest with you, basically every year, 2 years, you come and see me and we go through it. Says, has anything changed? If so, why don't we do this? Sometimes you change the beneficiaries. Sometimes you change the successor trustees. There's all these different things that we do. I'm going to be doing a seminar next year on some of these issues. We'll send you notice out when I'm going to do the seminar to invite you and you get more information. But if you need an affordable legal consultation, you can call the office, 702-870-1100. Our website is Massey and Massey, that's M-A-S-S-I, then A-N-D, and MASSI.com. Let you know everything that we do. I hope this information helps. Don't be afraid of this. Don't fear it. Just take control of your life, and believe it or not, once you get these things done, no matter how young or how old, you feel better about yourself. I wish you all a very Merry Christmas, a very happy holiday, and I thank you for the support you've given me during the year, and I'll see you next week.